Case CV01-23-14744. We are here today to begin the bench trial of the claims remaining in this action. I'm going to set out a brief list, I suppose, maybe not too brief list, of the lawyers here representing the parties to the case. Simple side, on the state's side, is Mr. Craig and Mr. Grigsby. On the plaintiff's side, I'm not sure who all is here, but we have at a minimum Ms. Dady, Mr. Cohen, Ms. Palavon, Ms. Dunham, Ms. Kasig, Mr. Herron. If we have others who would like to enter an appearance on the plaintiff's behalf, you're welcome to speak up.
Good morning, Your Honor. Anna Pletcher for the plaintiffs.
Thank you, Ms. Pletcher.
Good morning, Your Honor. Scott McKay for the plaintiffs.
All right, thank you. So, some preliminary matters. I had mentioned, I believe, during the pretrial conference that a hearing in another civil matter was scheduled for 4 o'clock today, and that we would finish up before then. That hearing is now vacated. If we are still rolling, we can go until 5 o'clock. There is a hearing in another matter set for tomorrow at 4:30, so that will now be the anticipated end time tomorrow. All right, now in terms of, I have one other preliminary matter that I wanted to discuss, and that is an argument made in the trial brief that Mr. Craig filed on the topic of sovereign immunity. The concern I have as to that, and I want to assess how serious the state is about pursuing that line of defense, is leaving aside for the moment whether it works, whether it's a viable defense as to count one, whether it's been waived because other than potentially a mention in the answer, it was not asserted at some prior point in the litigation. An issue for me is that it makes the rationale I had for dismissing Attorney General Labrador from the case early on untenable, because I dismissed him, also Governor Little, on the theory that they were simply duplicative defendants. Now, to the extent the state intends to defend a count one, on grounds of sovereign immunity, if I indulge the idea that that defense might work, the other defendants, at least Attorney General Labrador, is no longer, I guess, what I've termed a duplicative defendant, because he can't defend on sovereign immunity grounds. So to me, I think where we are is, if the state is going to pursue that line of defense to the declaratory judgment claim, then the likely consequence of that would be to rescind the order of dismissal as it relates to Attorney General Labrador. Because as I said, it undermined the assertion of a sovereign immunity defense for the first time, undermined the rationale for that dismissal. I think the rationale would still apply in a reasonable way as to Governor Little if Attorney General Labrador is in, because all you need is one. And it would seem that of the two, Attorney General Labrador is the more likely to be actually involved in enforcing the criminal laws at issue here. So, having said all that, I'm going to invite responses. Mr. Craig?
Thank you, Your Honor. So Attorney General Labrador would still enjoy sovereign immunity as well. He's being sued in his official capacity. This is not a 1983 action. This is a suit against the state. So Attorney General Labrador, as being sued in his official capacity as a representative, as an elected constitutional officer of the state of Idaho, would still also enjoy sovereign immunity. So it does not do anything to counteract the court's rationale, because Attorney General Labrador is also subject to sovereign immunity. He also enjoys that sovereign immunity. So in terms of the defense sovereign immunity, I don't think it changes the presentations at trial at all. I think the evidence is going to be the same. And so at this point, I don't think there's any prejudice to either party one way or the other, because all of the evidence that would be needed on count one is also needed for count three. And so for that reasons, it's not going to change trial at all. But AG Labrador enjoys sovereign immunity just as the state of Idaho enjoys sovereign immunity as well. Thank you.
All right. So I think that was a little different than and perhaps assumption I made. But in any event, if the defense, if the plaintiffs would like to address the subject, you're welcome to do that.
Thank you, Your Honor. First, we believe the state's sovereign immunity arguments are foreclosed by the Idaho Supreme Court's decision in Planned Parenthood versus Idaho. Second, the purpose of sovereign immunity is if the state enjoys sovereign immunity in a particular case, it would be to avoid trial, to avoid the entire process. So the time to make those sovereign immunity arguments would have been at the motion to dismiss stage, or at the latest at the motion for summary judgment. I do believe case law demonstrates that sovereign immunity is a waivable offense, or excuse me, is waivable. So if they have not made these arguments previously, they are waived. We should proceed as normal. Third, Attorney General Labrador does not enjoy sovereign immunity. There is no sovereign immunity under the doctrine that state officials who are violating the state constitution through enforcing a law can be sued for prospective equitable relief. That is exactly the relief that we are seeking in this case, and sovereign immunity does not protect state officials. So I believe that this trial should move forward exactly as planned. I think Your Honor's solution is a good solution, but I don't think we need to go there, because the state of Idaho does not enjoy sovereign immunity as held by the Idaho Supreme Court, and in any event, it is waived.
All right. So the gist of it is, from your standpoint, although you disagree with Mr. Craig that Attorney General Labrador would have sovereign immunity, you are not asking me to undo the order of dismissal of Attorney General Labrador because you think you're going to defeat the sovereign immunity defense regardless. Is that a fair summary?
Look, we disagreed with the court's dismissal of Attorney General Labrador. So, we would ask that you rescind that order and reconsider it, and reinstate him as a defendant. Our position all along has been relief against the state of Idaho, however, does extend to every state official, everyone exercising state power. And in fact, the Idaho Supreme Court has said that in the Planned Parenthood versus Idaho decision. So, we would be comfortable if you did want to rescind that dismissal as a bootstrap to make sure that we can proceed today as we have all planned.
All right. Well, I certainly don't have a problem with proceeding today, and if what Mr. Craig's is saying is equivalent to saying it's the way he defends the case on the state's behalf is the same way he'd defend the case on Attorney General Labrador's behalf, or Attorney General Labrador reinstated as a party, then I suppose we could simply proceed and without an immediate decision on this topic, and can address it as the trial, I guess, proceeds. If I'm forced to make a decision on the topic right now, I think my inclination, if the state is going to pursue a sovereign immunity defense, would be to bring the Attorney General back into the case. It may be that what Mr. Craig says is true, that he's got sovereign immunity as well. That's just not how I understood things. So, Mr. Craig, are you content with the idea of putting this issue on ice for the moment and proceeding, and then making a decision at some point here in the near future on how to proceed.
Yes, Your Honor, and the reason is because count 3 is a constitutional claim. They are alleged in violation of the Constitution, and that's where the Planned Parenthood case, the Tucker case, those lines say that there is no sovereign immunity as it relates to a constitutional claim. So we're not asserting sovereign immunity on count 3.
Understood.
so-
And I guess you're not contending that you would approach the defense of the case any differently with the Attorney General a party or a non-party. It's the same defense.
At this point, that is likely the case. If I could get an answer to you later, but yeah, at this point, I mean, we don't even start our case until next week, until the 20th, and so, but certainly in terms of cross-examining witnesses and those types of things, there would be no difference.
All right, understood. So we'll put that issue on ice and come back to it. It's certainly, I'm not in a position to be able to decide the immunity defense at this point. All right, so those were the preliminary matters I wanted to discuss. I suppose one more question I have is, at times, bench trials, there are parties are able to reach agreements in advance as to admissibility of certain exhibits. I don't know whether there are any stipulations concerning admissibility of evidence at this point.
Yeah, nothing that we need to take up now, Your Honor. We'll probably just cover that as we get to the exhibits.
All right. Do counsel then have any preliminary matters you want to discuss, or shall we move into opening statements?
Nothing from the plaintiffs. We're prepared to proceed.
We do have one thing, Your Honor.
Go ahead.
Thank you. So on Sunday night, late Sunday night, plaintiffs provided a disclosure of 1,800 pages of medical records to us. These are medical records that we had been requesting in discovery from the very beginning. We've been asserting from the very beginning of their disclosure to us that there were medical records that we thought were missing, and they asserted, no, there is not. You guys have everything. We raised it in numerous meet and confers. We sent them a letter saying that we think that there are medical records that are missing. They continue to tell us that, no, you guys have everything. And then on Sunday night, we got 1,800 pages of medical records. Now, some of those are absolutely copies of what they provided before. Because it was provided late Sunday night and Monday was a state holiday, we've not had a chance to do a full review of everything. My paralegal was able to look through some of it, and so some of it is absolutely duplicative of what we've provided before. But there's well over probably 500 or 600 pages of additional medical records that they did not provide to us. This is a clear violation of Rule 37. It's a clear violation of their duty to supplement records to us. And so we'd ask that under Rule 37C1, which states that if a party fails to supplement discovery responses when required, the party is not allowed to use that information or witness display evidence on a motion, at a hearing, or at a trial unless the failure was substantially justified or is harmless. They can't say that it's substantially justified. The records that they provided us say they didn't even request those records from the hospitals until end of October, beginning of November. It's a clear violation. They should be prohibited from asking any of the witnesses any questions about their medical history, given this clear violation of the discovery order. Thank you.
All right. Thank you, Mr. Craig. Mr. McKay?
Right. Good morning again, Your Honor. Let me start with a notion that we've somehow not complied with our discovery obligations. That's simply not true. In this case, we represent four patient plaintiffs who obtained their medical records themselves. When we received a discovery response from the state, we turned those medical records over to the state. And we intended to only make use of a subpart of those few medical records in connection with the presentation of our claims here. As we approached trial, we conferred with counsel like we were required to do about evidence, the admissibility of certain exhibits, witnesses, and the like. And somewhat remarkably, the state told us at that point that they would not agree to the authenticity of our clients' medical records. And so we were duty-bound to serve subpoenas on the custodians of records for the providers, in this case, St. Alphonsus and St. Luke's. And so we served those trial subpoenas. We just recently received medical records. We received medical records as late as Friday from St. Luke's. We went through those records. We applied redactions to PII and the other redactions that we had made during the course of discovery, and we turned those promptly over to the state. If the state felt during the course of this case, during discovery, that they did not have complete medical records, they had their own ability to obtain those records from the providers. They could have served subpoenas on the hospitals and obtained those records. And it was evident that, as counsel points out, it was evident from those records that it was not a complete set of everything. For example, the medical records for the plaintiffs refer to imaging, ultrasounds, which occur routinely in the course of prenatal care. And it was only when we received these records from the hospitals just recently, we received, for example, imaging, and that's part of that larger mass of documents that was turned over to the state. So now is not the time for them to complain that they don't have everything when this is really a problem of their own making. They could have pursued those records independent of us. They didn't. When we received the records because of their unwillingness to stipulate to the authenticity of a few medical records, we obtained a larger mass of records, which we promptly turned over. And I'm not hearing the state saying that they're prejudiced in any respect by what they've received. They have not identified for this court that this somehow impairs their defense of these constitutional claims.
Are the records that were produced for the first time over the weekend responsive to discovery requests served by the state?
Yes. So they were, in fact, then turned over to the records that we then came into possession of were turned over to the state. So they were responsive and provided to the state.
Are those records not in the possession, custody, and control of your individual clients as a matter of law, the patients? Do they not have, control in the form of a legal right to obtain the records from the providers?
And they obtained what they thought was, or what was represented to them was their medical records from the hospitals. But both sides knew, for example, if you look at those records that refer, for example, to I'm just using imaging as an example, an ultrasound, that those records did not contain an ultrasound. And a reading of that imaging is, and possession of that ultrasound is not necessary to the prosecution and presentation of these claims, nor, as I submit, is it necessary to the defense of these claims. So we turned over what we believed was the responsive set of medical records that we have, and when we received a fuller set, we turned over that fuller set to the state.
So what was done to obtain the plaintiff's medical records prior to the subpoenas?
Yeah, so it's my understanding that they would have had to have signed a release and a request for medical records.
So the patient plaintiffs signed releases from their medical providers, received whatever they received, and gave it to you. You gave it to the defense.
Yes, and I should add, though, too, with St. Luke's, for example, I think they use a system, possibly Your Honor is familiar with it, called MyChart. And so you can go onto MyChart and you can download all of your medical records through MyChart. And so that might have been the methodology that was utilized by the patient plaintiffs with respect to those records.
Okay, so they may have gathered their own records from their electronic MyChart accounts, as opposed to submitting some sort of some sort of a request to the providers themselves to produce documents.
Correct. And I believe, I've just been advised, that was only one plaintiff who followed that process utilizing my chart.
All right. So I guess what accounts for the growth in the universe of documents? I mean, from what your efforts, your client's efforts to gather the documents, short of a subpoena, and then what they obtain.
Yeah, I think that's a good question. I'm not sure that I have. I think that's something that the hospital could better address. But one is what I mentioned, the imaging. Another might be the formatting. For example, if you obtain documents from my chart, they're going to be in a particular format. If you obtain the documents from the hospital itself, it's going to be in a different format. And I suspect there's a whole bunch of extraneous records that have nothing to do with the claims in this case that were produced by the hospital. The hospital gets a subpoena that refers to a particular patient and says all of their records, they produce all of their records, irrespective of the sorting out of whether they have anything to do with this lawsuit.
So, all right. Well, is Mr. Craig correct when he says that he made efforts to put you on notice of the state's belief that the disclosures of medical records were incomplete, and there has to be more? Where is the more?
But it's simply self-evident from the records themselves that refer, for example, to an ultrasound. That refer, there's a deposition of Jillian St. Michelle that was taken in this case, where she's asked about an ultrasound that was obtained by a doctor. That ultrasound is not, a St. Al's doctor. That ultrasound is not within the medical records. So yes, he's correct that that they didn't have the complete medical records, but that was well known to the state. And the state has their own ability to pursue discovery, which they haven't. And again, I think we're talking respectfully, we're making this into a tempest in a teapot. There just is simply no prejudice here. We're going to offer a very limited subset of medical records that talk about the conditions of these plaintiffs. And all this, whatever extraneous material that was produced is simply not going to be material, and it's only going to be consistent with the claims that we're asserting.
All right. Well, I'm going to give Mr. Craig one last opportunity to address the matter, and then what I may do potentially is direct the plaintiff's side to provide me and Mr. Craig copies of the precise newly produced documents that you intend to use that had not been produced before, and we will make a decision ultimately on fuller information.
So we've done that. We've provided Mr. Craig with the precise records that we intend to use. And we're prepared, and this is somewhat unique in my experience, but we're prepared to call custodians of records from the two hospitals to establish authenticity of medical records, because the state wouldn't agree to it. So they have it, and we'll establish that they're authentic, and they're all consistent. They're all consistent, or the same records that they have had.
Well, if we wouldn't be talking about this if they were the same records, because you'd just say, it doesn't matter, I'll use the ones I already produced.
But the hospital's not in a position then to authenticate a record that has a bait stamp, has a redaction, that is in a format that they maybe gave it to the plaintiffs, but is not now currently maintained. And that was the challenge. That was the challenge we had when counsel raised this. So we've done what counsel has asked us to do. We're prepared to prove authenticity, and it has created this change or reformatting with a few of the records, if you will. But the state by no means can argue that they've been prejudiced here.
All right, understood. Thank you, Mr.
Thank you, Your
McKay.
Honor.
Go ahead, Mr. Craig.
Thank you, Your Honor. First of all, it's incorrect that they used a subpoena to obtain those documents. If they had used a subpoena, then they did not comply with the requirements to give us notice of a third-party subpoena ducis tecum. From what we can tell, all they did is they submitted a request to release those records from the patient. So again, if they used a subpoena, they did not give us copy of it as they're required to under the rules to serve a third-party subpoena ducis tecum. Now, it's interesting that plaintiffs are trying to blame the state for their failure to comply with the discovery, for their failure to obtain these records. These are records that they are wanting to use to support their case. They're not records that we were requesting for our case. They're records that they want to use to support their case. We submitted those discovery requests to them. They have an obligation to obtain those records that are in their control, and they have an obligation to provide those to us. This argument that we are not prejudiced is quite frankly frivolous. We don't know what those records would tell an expert witness because our expert witness has not had time to go through those hundreds and hundreds of pages of additional documents that he gave us. Our paralegal spent most of yesterday uploading those documents to our discovery software, trying to compare, seeing what she could do. You know, that took her away from other trial preparation work that we needed to do. So again, this argument that we are not prejudiced is frivolous. Further, Rule 37C1 does not have a requirement that the party be prejudiced in terms of what it states. It says, if a party fails to supplement discovery responses when required, the party is not allowed to use that information or witness to supply evidence on a motion, at a hearing, or at a trial, unless the failure is substantially justified or is harmless. There's no requirement for prejudice in there at all. Now, if all they had done was give us the identical records that they had provided us before with a business records affidavit, we wouldn't be here. Because that is all we requested when they said we refused to agree to the authentication of the records. All we said was that you have to comply with the rules, either by providing a custodian of a record or getting a business records affidavit. That's routine. That's every trial attorney knows that that's what you have to do to present records for us. It's not our obligation to authenticate that the stuff that they obtained is in fact authentic. So I think the fact that they're trying to switch the blame to the state shows that this rule applies and the court should prohibit them from providing any medical evidence at all from those four witnesses. Thank you.
All right, thank you. So what I'm going to say provisionally is that based on the information counsel provided, this is information that the defense sought in discovery through discovery requests. I'm gathering that the medical records at issue are responsive to defense discovery requests. Then the question becomes whether these newly produced records were in plaintiff's possession, custody, or control, such that plaintiffs had an obligation to produce them in response to the discovery requests that sought them. And they may not have been in plaintiff's possession or custody, but they would seem to be in plaintiff's control, because control is determined under case law to mean a legal right to obtain. And a legal right to obtain upon demand would appear to apply to the medical records at issue based on the information I have at this point. At least that is, I believe, the ordinary course of things that a patient may obtain from the patient's medical provider, her medical records. And if Mr. Craig's version of what happened exactly is correct, that these documents were not sought by subpoena, but rather by some sort of less formal request is the case, then that would tend to substantiate control, the ability to obtain, the right to obtain on demand. So it would seem that these additional discovery materials were responsive to discovery requests and were within plaintiff's control, and therefore an obligation to produce them attached, leaving aside whether the state could obtain them itself independently by subpoena, which is really not the issue. So it would seem that at this point there is a failure of some sort to provide discovery in a timely fashion. And in terms of whether this supplementation on Sunday before trial begins on Monday could be considered timely in some fashion, seasonable supplementation under Rule 26E, it would seem unlikely that it could be characterized as seasonable or timely supplementation. And that does raise the specter, as Mr. Craig suggests, of exclusion under Rule 37C1. And it would appear that may be an appropriate consequence. But one thing Mr. McKay is telling me is that if you look at these records that are newly produced, that they intend to use at trial, they're somehow an equivalent of some previously produced record that just is somehow in some different form that they may not be able to authenticate, whereas they'll be able to authenticate these new documents. I don't know how to judge where the truth in that lies, but I think where I am at this point is that the newly produced documents are provisionally excluded, and it'll be a burden on the plaintiff's part at this point to show me why, as to some particular newly produced document that you want to try to use at trial, why, if the argument is that this information really was produced to the defense in some equivalent form beforehand, but that form is supposedly can't be authenticated, but this one can, you're going to need to show me, and I'll consider on a case-by-case basis whether to permit any of the newly produced documents to be used. All right. Mr. McKay?
May I just make one clarification? I want to be clear. I possibly misspoke. And we have been working on really winnowing down the medical records that we intend to offer in this case. And our case is not dependent upon, these precise medical records. These plaintiffs are going to be able to come in here and testify to, their conditions and situations. And we have expert witnesses who are going to offer the same thing. This is so we're going to be able to prove this case. But I just want to say, when I said that we had told the state exactly the narrow subset of records that we wish to use, we may not have done that, but we're prepared to do that, and we're prepared to do exactly as Your Honor has described, to show the court that these are the same records that the state has had all along in this case.
All right. Well, I think if you want to try to salvage the best potential opportunity you have to use any of these newly disclosed records, step one would be providing a list by Bates number to opposing counsel as to which particular ones you want to use, and then, as I said, be prepared to show how it's essentially the same document, same content you already produced previously.
Very well.
All right. Let's then move on if we are ready for an opening statement. At this point, plaintiffs may proceed. Ms. Dady?
Thank you, Your Honor.
Morning, Your Honor. May it please the court. In April 2023, Jennifer Adkins and her husband were driving from their home in Caldwell, Idaho, to Portland, Oregon. They were on the road that day because Mrs. Adkins was denied an abortion in Idaho, despite receiving the devastating news at 12 weeks of pregnancy that her baby had a lethal fetal condition, and that condition was also putting Mrs. Adkins' life and health at risk. During that drive, Mrs. Adkins knew she could miscarry and potentially hemorrhage while on the road. She thought about this constantly as she and Mr. Adkins drove mile after mile through areas with no cell service and where any form of medical assistance was hours away. But Mrs. Adkins had no choice but to make that drive. She received abortion care outside her community, without her family and her support system, and without the Idaho physicians that she knew and trusted. She will tell you today that she made that trip to get the medical care she needed, not only for her own health and safety, but to also make sure that she could be there to parent her 18-month-old son. We're here today because of people like Mrs. Adkins and the hundreds of other Idahoans who have had to make the same trip, who have had to travel outside their communities to seek abortion care, or who have been required to remain pregnant, even under dangerous circumstances, since Idaho's abortion bans went into effect 2 years ago. I'm Gail Dady from the Center for Reproductive Rights. In addition to Mrs. Adkins, we represent Jelaine St. Mitchell, Kayla Smith, and Rebecca Vincent Brown, all of whom were denied abortion care here in Idaho. We also represent 2 Idaho physicians, Dr. Emily Corrigan and Dr. Julie Lyons, who provide obstetrics care in Idaho, as well as the Idaho Academy of Family Physicians, which is the chief medical association of family physicians in Idaho. This morning, I am going to preview plaintiff's evidence, which will show that the exceptions to Idaho's abortion bans are unworkable and that they inhibit Idahoans' ability to receive vital care. This endangers their lives and their health, including their fertility and in instances of lethal fetal diagnoses. Plaintiffs will first briefly discuss the abortion bans, and then plaintiffs will present the testimony of 4 plaintiffs who were unable to obtain necessary abortion care in Idaho. They will courageously describe the medical conditions that they suffered from and how the bans forced them to travel out of state to get the medical care that they needed. Next, plaintiffs will present 6 Idaho physicians, including plaintiffs Dr. Corrigan and Dr. Lyons, who will explain the many ways that Idaho's abortion bans have harmed their pregnant patients and wreaked havoc on their ability to provide the necessary evidence-based medical care they were trained to provide. Plaintiffs will also present evidence from 3 preeminent national experts who will testify about the national standards of care from the perspectives of emergency room physicians, maternal fetal medicine specialists, and mental health specialists. And plaintiffs will present evidence from a preeminent medical historian, which will provide historical context for plaintiffs' constitutional challenge to Claim 3. And the plaintiffs will present evidence of the state of Idaho's knowledge and exacerbation of the harms caused by the abortion bans. And then finally, I will summarize the relief that plaintiffs are requesting in this case. So before I describe the expected testimony in more detail, it's worth looking at the language of the abortion bans themselves. So first, there is Idaho's total abortion ban. Under this law, abortion is criminally prohibited at any stage of pregnancy unless, in the physician's good faith medical judgment, the abortion is necessary to prevent the death of the pregnant woman. That language is undefined, and we will show has no commonly accepted medical meaning. If the threat of death is from suicide or self-harm, abortion is foreclosed entirely. And the penalties under the total abortion ban are severe, including up to 5 years in state prison and loss of medical license. And second, there is Idaho's 6-week abortion ban. This ban bars physicians from providing abortion care after fetal cardiac activity is detectable, which typically occurs around 6 weeks after a pregnant patient's last menstrual period, before most women realize that they're pregnant. It contains an exception for a medical emergency, but the exception uses different language and standards to judge a physician's conduct than the total abortion ban does. And the 6-week abortion ban is enforced by civil penalties, but it is also enforced by criminal and licensure penalties in circumstances where the total abortion ban is not enforceable. So with that background, I want to turn to the reason that we're here today, which is the plaintiffs in this case. You will hear from plaintiffs Jennifer Adkins, Jelaine St. Mitchell, Kayla Smith, and Rebecca Vincent Brown. All 4 of these women were overjoyed to be pregnant with their second child. And then each of them received the worst news that a happily expectant mother can imagine. Their babies had devastating and lethal fetal conditions and would either not survive the pregnancy or would suffer and die shortly after birth. All 4 of these women decided to have an abortion to protect their health, to spare their babies from pain and suffering, and to remain alive and healthy to parent their young children. Now, I've already shared part of Mrs. Adkins' experience. Her baby was diagnosed with severe developmental conditions, which were in turn putting her at risk of a serious and potentially fatal medical condition called Muir syndrome. Jelaine St. Mitchell's baby had an array of severe structural and chromosomal conditions that provided no chance of sustained life after birth. Ms. St. Mitchell believes that abortion was the most compassionate choice that she could make as a mother to protect her baby from pain and suffering. After she was denied care in Boise, she was forced to travel to Seattle, Washington to get the care that she needed. And Kayla Smith's baby had multiple severe heart conditions that many pediatric cardiologists from across the country found to be inoperable. Ms. Smith had preeclampsia during her first pregnancy, and she was at risk of that recurring during her second. And despite this risk to her health, Mrs. Smith was denied abortion care in Idaho and had to travel to Seattle to get the care she needed. And then you will hear from Rebecca Vincent Brown, who will tell you that her baby's diagnosis of triploidy, which is a fatal genetic condition, was putting her in danger of miscarriage, severe hemorrhaging, and preeclampsia. After Ms. Vincent Brown was denied abortion care here in Idaho, like Mrs. Adkins, she and her husband made the drive to Portland, Oregon to get care. And after traveling out of state, away from her care team and family, her pregnancy ended in a way that no one would want. On the hotel bathroom floor, while stifling her cries of pain to avoid waking her toddler, who was sleeping in a pack-and-play on the other side of the door. These patients are representative of pregnant Idahoans who seek abortion care to preserve their lives or their health, or who are asking to be spared the anguish of being forced to continue a pregnancy, knowing full well that their baby will not make it to birth, or will not survive birth, or that they will be forced to watch suffer and die shortly after birth. You will also hear from medical professionals in this case, starting with plaintiff Dr. Emily Corrigan, who is an OBGYN at St. Alphonsus Regional Medical Center in Boise. Dr. Corrigan is responsible for treating patients at her hospital with serious pregnancy complications. She will explain that treatment for such patients often includes safe, common abortion procedures when they are necessary to alleviate conditions posing risks to the patient's life or serious health risks. Dr. Corrigan will also present expert testimony. She will explain that there is no bright line between a pregnancy condition that poses a risk of death and one that poses a risk of serious injury. And OBGYNs are not trained to decipher such a line. They are instead trained to provide evidence-based medicine, and to offer their patients timely treatment. They are trained to provide care according to national standards, which require them to provide timely abortion care to prevent a patient's health from deteriorating to the point that an abortion becomes necessary to prevent their death. Dr. Corrigan will testify that the ban's medical exceptions are unclear and cannot practically and reliably be applied to her real-world patients. And she will also testify that patients seeking abortion care for likely fatal fetal conditions and other serious threats to their health or even to their lives have been turned away from hospitals across Idaho because of the bans. You will also hear from plaintiff Dr. Julie Lyons, who provides family medicine and obstetrics care in Haley, Idaho. Dr. Lyons also struggles with how to treat her patients under the uncertainty created by the ban's medical exceptions. The patients Dr. Lyons treats often have high-risk pregnancies, and the rampant fear and confusion among physicians and medical staff about how to apply the ban's exceptions have strained her hospital's limited resources. Patients with non-viable pregnancies and serious health risks have been turned away from Dr. Lyons' hospital due to the bans, and they have been forced to seek care out of state or to carry dangerous pregnancies to term. Dr. Lyons will also provide expert testimony in this case, and she will explain that family physicians are critical to the maternal health system in Idaho, and particularly in rural areas. But the unworkability of the medical exceptions has exacerbated maternal health care deserts and created difficulties recruiting physicians to practice obstetrics in rural areas. And you will also hear from Elizabeth Woodruff, the executive director of Plaintiff Idaho Academy of Family Physicians. Ms. Woodruff will testify about the impacts of the bans on IAFP members who treat pregnant patients in Idaho. So after the bans went into effect, IAFP received urgent concerns from its members about how to provide and participate in providing in life or health-preserving abortion care under the ban's exceptions. And IAFP responded by holding listening sessions with legal experts, preparing educational materials and presentations, engaging in public education and legislative advocacy, and participating in including forming new coalitions of doctors, lawyers, and other health associations. But ultimately, none of these efforts resolved IAFP members' concerns or made the ban's exceptions work for their patients. Ms. Woodruff will also tell you about how she has witnessed how the lack of a workable medical exception for pregnant patients has impacted Idaho's physician workforce. But it's not just the named plaintiffs who will testify about the harms from the abortion bans. Other Idaho physicians across a range of different practices, family physicians and specialists, urban and rural, encounter the same problems from the bans. You will hear from Dr. Lauren Colson and Dr. Nicole Aker, both of whom are IAFP members. Dr. Colson is a family physician who provides gynecological and obstetrics care in Boise. He also trains medical residents in obstetrics, and he's on the IAFP's board of directors. Dr. Aker is a family physician who provides obstetrics care in Mountain Home. Now, Dr. Aker and Dr. Colson will each testify about the unworkability of the medical exceptions in their own treatment of pregnant patients, as well as the perilous confusion that the bans have caused for physicians and medical staff, resulting in patient harm. You will also hear from Dr. Duncan Harmon and Dr. John Wardell. Dr. Harmon is an OBGYN who practices in St. Luke's Maternal Fetal Medicine Group in Boise. Dr. Wardell was, until recently, the medical director of St. Luke's Women's Services line, which covers all obstetrics care provided within St. Luke's health system. Dr. Harmon and Dr. Wardell will testify about how the abortion bans have negatively impacted St. Luke's physicians and patients, as well as St. Luke's ability to retain and recruit the physician workforce that it needs to optimize care for pregnant Idahoans. You will also hear from 3 nationally recognized experts in multiple specialties. Dr. Catherine Wenstrom is a triple board certified OBGYN, maternal fetal medicine specialist, and geneticist. She is a former member of the American College of Obstetricians and Gynecologists Board of Directors, and a former president of the Society for Maternal Fetal Medicine. Dr. Ali Raja is a practicing board-certified emergency medicine physician. He is currently the co-chief of staff of Massachusetts General Hospital's emergency department. And Dr. Jennifer Payne is a board-certified psychiatrist who specializes in reproductive psychiatry and the management of perinatal mental health conditions. She is the director of the Reproductive Psychiatry Research Program at the University of Virginia. These experts will describe circumstances in which abortion is within the standard of care to protect pregnant patients' health and lives. Plaintiffs will also present testimony from Dr. Shannon Withicombe, who is an expert in the history of medicine in the United States. And as the court knows, plaintiffs contend that under Article 1, Section 1 of the Idaho Constitution, the inalienable rights to enjoy and defend life, pursue happiness, and secure safety mean that the state cannot block pregnant Idahoans from accessing otherwise available life and health-preserving health care, and that includes abortion care. It's including when it is necessary to protect future fertility and in instances of fatal fetal diagnoses. Dr. Withicombe will provide background and context about the life-saving and health-preserving abortion care that is deeply rooted in Idaho's history, including in 1889 when the Idaho Constitution and its Inalienable Rights Clause were drafted. Dr. Withicombe will testify about the ample historical evidence that physicians in Idaho and across the United States enjoyed broad discretion in the late 1800s to provide therapeutic abortion care to preserve their patient's life or their health. And that includes to protect future fertility in instances where the pregnancy was causing or contributing to mental health conditions and self-harm, and when a fetal condition rendered a pregnancy non-viable or dangerous. Dr. Withicombe will testify that there was widespread recognition among 19th century physicians that the life and health of the pregnant woman should take precedence over that of her pregnancy. And finally, you will hear from 2 employees of the Idaho Department of Health and Welfare, Elke Shaw-Tulloch and Jennifer Lipashak. Their testimony will establish that the state is aware of the widespread unworkability of the medical exceptions and has not provided any official guidance to physicians or to other medical providers on how to practice within the national standard of care and avoid criminal penalties or civil liability under the bans. Nearly all deaths reviewed by the Idaho Maternal Mortality Review Committee were preventable, and mental health conditions were the most common underlying cause of preventable pregnancy-related deaths in Idaho between 2018 and 2021. And their testimony will establish that deaths caused by Idaho's abortion bans would likely have been captured by the Maternal Mortality Review Committee if the legislature had not allowed it to sunset in June 2023, less than a year after the abortion bans went into effect. Now, defendant State of Idaho is responsible for enforcing the bans, and the state is well aware of the harms the bans are causing. Yet the state offers no official guidance or interpretations of the bans. Instead, the state and the Attorney General file public positions in one lawsuit that says specific medical conditions or patient presentations qualify for an exception. And then they file a position in another lawsuit saying the opposite, or saying that it's not possible to determine whether exceptions apply one way or the other. And even in the state's responses to plaintiffs' request for admission in this case, they claim that it's not possible to say one way or another whether various conditions and scenarios would qualify for an exception, even when their own medical expert, Dr. Ingrid Skopp, says the exact same conditions and scenarios would clearly be allowed under the exceptions. The state's constantly shifting positions have made it even more challenging for physicians to rely on the medical exceptions. And yet both the state and their expert, Dr. Skopp, will blame physicians for not understanding how to apply the exceptions to their real-world patients. Now, at the close of evidence, we're going to ask the court for two things. First, a declaratory judgment that eliminates the uncertainty in the exceptions by declaring when those exceptions allow physicians to provide abortion care. And second, plaintiffs will ask you to uphold the constitutional rights of Idahoans guaranteed in Article 1, Section 1, including the rights to enjoy and defend life, pursue happiness, and secure safety, as well as the right to procreate. Now, regardless of how the state characterizes plaintiff's case, our requested relief is not about allowing abortions under all circumstances. We are focused on high-risk pregnancies, and that encompasses three categories of patients. First, patients with medical conditions or pregnancy complications that endanger their life or health, including their fertility. Second, patients with pre-existing or underlying medical conditions that cannot effectively be treated during pregnancy. And third, plaintiffs with a lethal fetal diagnosis. You will hear testimony from physicians over the next 2 weeks that the narrowness of the exceptions is precluding physicians from providing adequate care to these three categories of patients. The critical medical question in this case is who should be able to receive abortion care under the medical exceptions to the abortion bans. Over 2 years after these laws went into effect, no one has an answer to that question. Now, the parties have sharply divergent views of the medical exceptions. The state appears to believe that the lives and health of living, breathing, pregnant Idahoans, people's sisters, mothers, wives, friends, are inherently less valuable than a developing fetus or embryo, and that continued pregnancy and childbirth must be forced in all situations and at all costs, except when both the woman and the developing pregnancy would be lost without an abortion. Now, plaintiffs have a different view, and plaintiffs will show that the Idaho Constitution demands more than that. The lives and health of pregnant people are worthy of protection, and that is the bare minimum of what is required under the law. Thank you.
All right. Thank you, Ms. Davey. Mr. Craig, would you like to give an opening statement at this time?
Yes, Your Honor, thank you.
Go right ahead.
Unborn children have a fundamental right to life, and protecting the lives of unborn children is a legitimate and a compelling governmental interest. Now, Idaho also has a legitimate and compelling governmental interest in protecting the lives of women. Idaho's Defense of Life Act and Idaho's Fetal Heartbeat Preborn Child Protection Act protect the lives of unborn children and protect the lives of pregnant women. The law in Idaho is therefore very clear. The killing of an unborn child through abortion is illegal in most circumstances. Evidence will show that this protects both the life of the unborn child and the lives of the mothers. In the rare circumstances in which an abortion is necessary to prevent the death of the mother, Idaho allows an abortion in order to protect her life. The evidence will show that every successful abortion results in the death of an unborn child. Every one of them. Idaho has a right to protect these precious lives. How to best protect those lives through Idaho's laws is a policy decision for the Idaho legislature. It's for the people of the state of Idaho, reserved to the people of the state of Idaho through their elected representatives. Plaintiffs, however, are asking this court to usurp the role of the legislature, to usurp the role of the people of the state of Idaho and make different policy choices. They're asking the court to write into the law exceptions that do not exist, that the Idaho legislature has decided not to add. Essentially, they're saying, Judge, we don't like the language that's in the law, so just rewrite the law. Give us something that we like better. That's not the role of this court. The role of the court is to determine concrete facts and then apply the law to those facts. But the evidence will show that plaintiffs have no evidence of concrete facts. They have no evidence of facts for which they are requesting relief. Rather, they're relying on hypotheticals and speculation as to what might happen to other people. Thus, the court will be unable to exercise its most basic function to determine what the facts are and then apply the law to those facts. Now, Ms. Atkins, Ms. Smith, Ms. Vincent Brown, and Ms. St. Michel, they face tragic circumstances. They face tragic pregnancies. We do not deny that. No one would want to have to face those circumstances. But they are not here before this court asking for relief related to those pregnancies. For Claim 1, plaintiffs will be presenting evidence to try to convince the court that the court should rewrite new exceptions into the law that don't exist. They're asking the court to declare that Idaho's Defense of Life Act and Fetal Heartbeat Preborn Child Protection Act allow a physician to provide a woman an abortion when the physician determines that the woman has, quote, an emergent medical condition that poses a risk of death or risk to her health, including her fertility, end quote. They are also asking the court to declare that Idaho's laws allow an abortion, among other times, any time that a pregnant woman has a medical condition that poses a risk of infection, and any time the baby has a fetal condition where the fetus is unlikely to survive the pregnancy and sustain life after birth. It's important that the court focuses on what they are asking here. As we just heard during their opening statement, they're going to try to distract the court with all kinds of evidence that has no relevance to the actual claim that the court has to decide. They are asking the court to declare that women have a right to kill their unborn child for no other reason than the fact that the baby is disabled. They're asking the court to declare that women have a right to kill their baby, their unborn child, anytime they have a risk of infection. So let's talk about what the evidence will show regarding those. Plaintiffs define emergent medical condition as a condition in which the patient, quote, the patient presents with symptoms of an illness or injury that may progress in severity or result in complications with a high probability for morbidity if treatment is not begun quickly. The term morbidity is often confused with the term mortality. Mortality is death. Morbidity, on the other hand, is simply a disease state or a symptom, affected by, caused by, causing, or characteristic of a disease. So this brings within their definition, the plaintiff's own definition set forth in the complaint, of emergent medical condition, just about any potential health issue that any pregnant woman could face, no matter how minor or how treatable. For Claim 1, they don't even have a caveat added in there that the abortion is necessary to alleviate the risk posed by the illness or injury. They added that for Claim 3, but they don't even have that for Claim 1 for what they're asking the court to do. So let's apply that to a hypothetical scenario. If a pregnant woman steps on a rusty nail which pierces the skin, she would have an injury. The evidence will show that when you get a significant puncture wound from a rusty nail, you have to worry about tetanus. Everyone knows that you have to worry about tetanus. If you have not received a vaccination recently and you don't get treated with an updated vaccination, well then that puncture of a rusty nail, it may progress in severity with a high probability for morbidity. So the evidence will show that stepping on a rusty nail poses a risk of infection. Stepping on a rusty nail poses a risk to the health of the woman that may progress with a high probability for morbidity if treatment is not begun quickly. So according to plaintiff's definitions of emergent medical condition, a pregnant woman who steps on a rusty nail will have an emergent medical condition that poses a risk of death or a risk to that pregnant woman's health. And according to the plaintiff's theory, under Claim 1, as set forth in their complaint, that woman is entitled to an abortion under Idaho's law. Never mind that there's a simple treatment for stepping on a rusty nail, and that's simply to get a tetanus booster shot. Idaho law does not support plaintiff's theory. Plaintiffs are also asking this court to allow abortions for no other reason except for the baby's disability. Idaho's law does not support such an expansive theory. The Idaho Supreme Court shot down that theory in the Planned Parenthood case. They declared that the purpose of the law is to protect the unborn child's life when there is, quote, some chance of survival. And the Idaho Supreme Court put an emphasis on the word some by italicizing it in the decision. If there is some chance of survival, that is the purpose of the law, is to protect that unborn child's life. Plaintiff's argument for Claim 1 fails. Claim 3, they're arguing that Idaho's Defense of Life Act and Idaho's Fetal Heartbeat Preborn Child Protection Act violate a pregnant woman's right under Article 1, Section 1 to enjoying and defending life, pursuing happiness, and securing safety. Now, they're not presenting the specific facts of a specific woman who claims to need an abortion moving forward. So they're going to have to prove that Idaho's laws are unconstitutional in every situation in which any emergent medical condition presents in a pregnant woman that poses a risk of death or a risk to her health. So plaintiffs have to prove in every situation of an emergent medical condition that Idaho's abortion laws impact a right protected by Article 1, Section 1 of the Idaho Constitution. The evidence will show that Idaho's laws do not impact a constitutional right protected by Idaho's Constitution in any, much less every, situation involving any emergent medical condition. There is no right to abortion in Idaho's Constitution. There is no right to abortion in Article 1, Section 1. It doesn't matter how the plaintiffs try to articulate that right. It doesn't matter whether you call it abortion care, health care, or whatever other euphemism they want to use to hide the fact that every abortion ends in the death of an unborn child. There is no right to abortion in Idaho's Constitution. The evidence will also show that not every emergent medical condition even arguably impacts a right protected by Idaho's Constitution. Plaintiff's broad definition of emergent medical condition includes everything from highly treatable minor bouts of morning sickness to treatable preeclampsia without severe features to prom at 30 weeks gestation where one can simply deliver a baby safely. Now, for Claim 3, they did at least add into their complaint a caveat that the abortion must prevent or alleviate the risk posed by the injury. So let's take that definition and look at one example. Hyperemesis gravidarum simply means uncontrollable vomiting caused by pregnancy. Usually occurs in the first trimester of pregnancy. Now, an abortion might alleviate the risk posed by that condition, since if you kill the unborn child and remove it from the woman would no longer be pregnant, so she would no longer have the hyperemesis gravidarum. But the evidence will also show that hyperemesis gravidarum is highly treatable, and it can be treated without performing an abortion. So applying Idaho's laws to require her to be treated for hyperemesis gravidarum by some means other than killing the unborn child, that simply does not impact any constitutional right. Now, this is just one example out of many. But one example is all that is needed to defeat plaintiff's claim, since they have to prove that it's unconstitutional in every situation of an emergent medical condition. Now, it's also important to briefly touch upon plaintiff's desire to have the court declare that an abortion is allowed to protect a woman's fertility. Now, Idaho case law does not protect a right to fertility. Now, the Idaho Supreme Court has said there's a right to procreate, but that's not the same thing as a right to fertility. It would defy common sense to say that a right to procreate, the right to bring a life into this world, includes a right to destroy life. The evidence will show that killing an unborn child is not protected by a right to procreate. Further, there is no right violated by Idaho's laws when there is an emergent medical condition that poses a risk of death to the pregnant woman. This is because abortion is allowed when a physician determines that an abortion is necessary to prevent the death of the woman. And so there is no right violated or even impacted in those situations. Idaho's laws allow abortions in the rare circumstances when it's necessary to prevent the death of the woman. If there is at least one situation in which Idaho's laws can be constitutionally applied under their scenario, then plaintiff's claims fail. The evidence will also show that Idaho's laws can be constitutionally applied in all these situations. Finally, the state of Idaho has legitimate and compelling governmental interests in protecting the life of the unborn child, in protecting maternal health and safety, in eliminating gruesome and barbaric medical procedures, in preserving the integrity of the medical profession, in mitigating fetal pain, and in preventing discrimination on the basis of race, sex, or disability. Evidence will show that every successful abortion ends the life of an unborn child, and Idaho's abortion laws advance Idaho's compelling governmental interest in protecting the lives of unborn children. The evidence will show that the dilation and extraction procedure commonly used in second trimester abortions is barbaric and gruesome. And that procedure, it involves tearing apart a baby limb by limb to pull the baby out of the mother, and then crushing the baby's skull to pull it out of the mother. That is barbaric and that is gruesome, and Idaho's laws advance its right to eliminate barbaric and gruesome medical procedures. The evidence will show that Idaho's abortion laws are necessary to prevent discrimination on the basis of disability. This is evident by the mere fact that plaintiffs are arguing that Idaho's laws should be read to allow an abortion for no other reason than the baby's disability. The evidence will show that Idaho's laws protect maternal health and safety by preventing unnecessary procedures that can pose a risk to her health and her life. The evidence will show that Idaho's abortion laws prevent unborn children from being exposed to pain by the abortion procedure. The evidence will show that Idaho's laws are narrowly tailored to advance all of these legitimate and compelling governmental interests. Idaho's laws can be constitutionally applied, and plaintiffs will be unable to present evidence showing that they are unconstitutional in every situation involving an emergent medical condition. So at the end of the trial, evidence will be clear. Idaho's laws are constitutional. The plaintiff's claims fail, and the state will therefore request court issue a verdict denying plaintiffs all requested relief. Thank you.
Thank you, Mr. Craig. All right. Well, perhaps we just as well take a short break before the evidence begins. We'll plan to resume court at 10:30. We'll be in recess.
All rise.